The devil filed a lawsuit. Heaven or hell, your choice. That's our series. And today we're going to talk about answer or admit. Now, the devil's put together a lawsuit and has served that lawsuit on you, but there's still options for you to resolve. Obviously, you should talk to an attorney about a situation like this so that you can get sound legal advice. And if you're going to contest this lawsuit, you must file an answer with the court clerk, usually within 30 days of the day of being served. An exception to this is a complaint for replevin. Remember, we talked about that in the last one. That's where the creditors or the devil is trying to take something from you, right? Now, that allows you 5 days to object to entry of an order of delivery. So if you've got a replevin thing, you got to file an objection to the entry of an order of delivery within 5 days of the day of being served. Otherwise, they'll be able to come out and take the vehicle or the mobile home or whatever it may be. All right, the answer that you file with the court must admit or deny each paragraph of the devil's lawsuit. You must sign the answer and send the devil's favorite son a copy of it. Now, if you don't file an answer, the creditor, the devil, is going to get a default judgment against you and get whatever it was he was asking for normally. So again, the best thing is to talk to a lawyer about this. All right, if you have a legal defense, in other words, a legal reason that you don't owe the creditor, or you may owe less than what they say, or if you have an affirmative defense, and there's several of them, those defenses must be described in your answer. Otherwise, it could be waived and you not be able to use that. So the affirmative defenses that are available are, number one, accord and satisfaction. That means that you settled the matter sometime back and you've already paid it off. Number two is you've discharged it in bankruptcy. In other words, you filed bankruptcy and you got forgiveness of it. Number three would be payment. You paid it off. Number four is res judicata. That's another Latin term that means you've already gone to court on the matter and the matter's been decided. Number five is set off, meaning the creditor owes you for something. So if he's saying that you owe him, well, you're saying that he owes you and it should be offset. Then there's something called the statute of frauds, which means the matter should be in writing, but it wasn't in writing. And then the last is the statute of limitations. In other words, the devil waited too long to bring their lawsuit against you. And there are statute of limitations that bars somebody that wants to claim if they don't file within a certain length of time. So medical bills are like 2 years from the date of service or the last date of payment. A debt on an account is 3 years. An oral agreement is 3 years. A written agreement is 5 years. So if you have something like that, that's an affirmative defense. It has to be contained in your answer. Next is a countercomplaint. If you believe the person suing you owes you money, you may need to file a countercomplaint and set out the basis for it. This needs to be done along with your answer if possible. And if you don't, there is a possibility that you could waive your right to make that claim against the person that's suing you. All right. So our next post is going to discuss several traps for the unfamiliar. And the devil will definitely use them against you at every opportunity. So that's what we're going to talk about next time. Meanwhile, we stand ready to provide you a free, no obligation debt consultation to discuss your options. It's $150 value, free of charge. And if you'd like a copy of the book that's the basis for our talks, the devil filed a lawsuit, heaven or hell, your choice. It's a $24.99 value. We could send that to you free of charge also. Just go online or give our office a call and we'll be happy to fill your request. You have a great day and I look forward to seeing you where we're going to talk about traps for the unfamiliar.